On painful matter.
Yes.
What painful matter? That was listed before your lordship on 3/5/2020. That was left over lordship. In fact, lordship, in this case, lordship, there was an order to pay provisional pension. That was not paid. On the last day, your lordship has directed to obtain instruction as to why the provisional pension has not been given in the petition. So we have to lordship, this matter may come up on Friday.
It was left over.
Left over on 3/5. You are directed to obtain instruction as to why the pension has provisional pension has not been paid in terms of interim order. But on the last of day lordship, the matter was not paid.
Hello. We'll have it on 21st. Today is what?
Today is lordship 16th.
Oh, I don't know. Okay. Yeah, we'll have it on 22nd.
Maybe meant for listing in IMI because statement 8/5/2021.
For what?
For vacating the stay order matter regarding the Kavura matter. And in that day, my lord, matters were left over matter. They are enjoying.
Kavura? I don't remember giving any stay.
They are enjoying stay matter.
This court granted a stay.
No, my lord.
Then why are you mentioning before this court?
My lord, this is court listed this matter on 8 matter.
This is appointment of a Kavura.
Yes, madam.
This court has stated.
Yes, my lord. That letter is left over. On 8/5/2020, matter was listed this court.
Before this court.
Yes, madam.
Then why is it not listed? Was it an ex parte order?
Yes, madam.
So you should wait
My lord,
for 14 days and then automatically it vacates. Doesn't it? 226(3).
They are enjoying stay order, my lord. So matter. Kindly.
Okay, we'll have it on. When did you file it?
My lord, it was early file, my lord. Long way file.
I passed the order on 8/5.
No, that day it was left over.
Hello. We'll have it on 24th.
Kindly before. Kindly before.
Huh?
Kindly before 24th.
24th May.
22, my lord. Kindly.
Okay, we'll make it on 26. 26. 26. Yes.
I beg to mention item number 7, 9, 10, and 12. My lord, this matter may become infectious.
Item number 7,
9,
9,
10, and 12.
10, and 12. Why?
My lord, they have got the salary. This case was filed for salary.
They've got the salary.
Yes.
Okay. Item number 7, 9,
10, and 12.
10, and 12. Or Mr.
Okay, colleague.
K. Kolita.
Yes, sir.
You are there in the other matters. K. Kolita, the learned counsel appearing on behalf of the petitioner, who submits that he has instructions to withdraw the writ petitions, taking into account that the petitioners have already got their salaries.
Right.
Taking into account the above, the instant petition stands dismissed as it has become infructuous.
Lordship may pay for listing of an case, lordship. It is a suspension matter.
In the?
It is a suspension matter, lordship.
Okay.
And lord, that matter was initially listed on in the month of October. Thereafter, again listed on the next week, last week, lordship. Last Wednesday. On that day, matter was not reached, lordship. So may I pray for listing of this case, lord?
Okay. 24th.
24.
You were lucky. Otherwise, it was 26. Because of his matter, it is now 20.
Item number 1 for admission.
My lord, in this case, earlier occasion, was need to give the time.
Mite? Yes.
Well, in this case, earlier occasion they took time for filing the whichever was a directive for producing record law.
What is your matter about?
Matter relating to that, while my service suspension period was regularized, the penalty that was imposed that was not removed. And this ground was that the suspension that was subject to the approval of the higher authority, and for long 10 years that was remained. I was reinstated after that the approval was come, and when the approval come, the penalty still remain. So that is after reinstatement. So my case was that the entire suspension period was irregular. That is cannot be
What was the penalty?
penalty 1 year, withdrawal of 1 year increment cumulative
1 year increment was what?
salary, my lord.
Show me that.
My lord.
Show me. Are you not ready with your matter?
Yes, my
If you are ready with
Annexer-
your matter, then do
annexer-
your matter. We
annexer
will take
A-
it up whether they do. If they
I-
don't file it, then also if you are entitled to the relief, I'll grant you.
Yes, my
If you don't want, no problem. There are many lawyers who are waiting for their chance today.
Yes.
Yes.
I am sorry, my lordship. Kindly turn to page 41. My.
Yes. On the basis of the inquiry report of the Iman, so is hereby reinstated in service and posted to the office of AI expired by copies of 1 year with cumulative effect. Now there is no mention as regards the suspension period
Suspension period
as
have-
to whether it would be on duty or not.
that is regularized. My lord. In
Where
sub-
is it?
Yes, my lord. That is in annexer 17 at page 50, my lord.
Page
50. My lord. After filing my representation on that issue,
whereas so and so period of suspension is hereby regularized for all purposes. However, the penalty imposed against him will remain same whether he consents to punctual and so and so. Now, what is your yes? Now, what do you want?
this should go, my lord. This is a penalty that should go, my lord.
So you are challenging the penalty of 1 year.
Yes.
Why?
Because my lord, kindly see, my lord, the
Let us see the inquiry report.
inquiry report at page, my lord, annexer.
Then
10,
why haven't you filed an appeal?
my
Have you
lord.
filed an appeal against this?
My lord, yes, my lord, I have filed my lord the representation before the authority concerned. My lord.
Appeal.
Appeal, no.
Then why haven't you filed an appeal?
My lord, here, my lord, one thing, my lord. Earlier occasion, one requisition was filed. That was 6910, my lord, 2021. So while the, my lord, that case was filed, then, my lord, they have regularized my suspension period. And but the penalty remains same. So that is why, my lord, the second requisition was filed.
Understood.
Yes, my lord.
That means in long and short, you are challenging the order passed in a departmental inquiry proceeding.
Yes.
Then when the appeal is there,
Yes.
why the appellate forum was not been resorted to?
But the inquiry report, my lord, your lordship will get at page 39.
No, why should I look into this inquiry on the question of facts?
Kindly, my lord. Say.
No, unless there is a question of perversity.
Yes, my lord.
Why? How can this court look into? You know the limited scope of the jurisdiction of this court under 226.
My lord,
Yeah.
the proper appeal was not filed.
Huh?
But in sense, but a proper appeal was not filed.
What is
But
this
the-
proper appeal? No.
difficult is this one. That was happened in another code also. Here is there. The removal of this class can only be hard. Well,
How have you done this?
OCD. কিবা কাম এটা কৰিব লাগিব PhD ডিপাৰ্টমেণ্ট কিন্তু পইচাটা গম ল'লে PTC ফুল এনকুৱাৰী কৰ বস্তুটো খাতিলা বা হেৰি কৰিব অৰ্ডাৰ দিলে ৰিকভাৰী প্ৰচিডিউৰ ইয়াতে আছে ডিপি কৰিব লাগিব
So the direction to recover
Yes, sir.
has to be on the basis of an inquiry.
Yes.
There's no inquiry.
Yes, apparently from the face of this the order you achieve, there is no inquiry held. You achieve. So far as departmental inquiry, it ought to have been established.
This is the only thing which is required.
Yes, yes.
So we set aside this. Heard me, sir? A Gohain, the learned counsel for the petitioner. Mr. K. Kumar appears on behalf of the respondent number 1, 3,
Okay, number.
5, and 6. Mr. D. Gogoi appears for the respondent number 2.
Two, madam.
No government advocate? There, Mr. H. Who wants to appear? Mr. A. Chakraborty appears for the respondent number 4.
See.
Instant writ petition has been filed challenging order dated 29/11/2011 as well as the order dated 20/12/2011. Is relevant to take note of that in the order dated 29/11/2011, the principal secretary to the government of Assam, Panchayat and Rural Development Department, had directed that an amount of rupees 54,000 was misappropriated. That an amount of rupees that directed that as an amount of rupees 54,000 was misappropriated by the petitioner through payment made against false marks to the contractor. A direction was issued to recover the said amount from the petitioner. Subsequent to the order dated 29/11/2011, the Chief Executive Officer of the Dhemaji Jilla Parishad had further directed the petitioner to refund the amount of 54,000 within 7 days from the date of receipt of the letter without fail. The learned counsel for the petitioner submitted that in terms with the Assam Discipline and Appeal Rules, 1964, the major and minor penalties have been specifically mentioned. Mentioned in Rule 7. The learned counsel for the petitioner drawing the attention to Rule 7.3, Roman 3, of the rules of 1964 submits that the penalty for recovery of any amount has to be done so on the basis of an inquiry held in terms with Rule 9 of the rules of 1964. However, without any inquiry, as envisaged under Rule 9, the impugned orders have been issued by the respondent number 1 as well as the respondent number 5. And as such, the said orders are liable to be interfered with. It appears on record that there is an affidavit filed by the respondent number 5 on 2nd of August 2012. From a perusal of the records affidavit, it does not transpire that there was any inquiry held in terms with Rule 9 to inflict the punishment under Rule 7, Roman 3 of the rules of 1964 upon the petitioner. Taking into account that it is the mandate of the provisions of the rules of 1964, more particularly Rule 9, to that no penalty specified under Rule 7 shall be passed except after an inquiry held as far as practicable in the manner laid in Rule 9. The impugned orders dated 29/11/2011 issued by the respondent number 1, as well as the order dated 20/12/2011 issued by the respondent number 5 are set aside and quashed. With the above, the petition stands disposed.
Liberty may be granted to the department.
Full stop. For parting with the record, this court deems it appropriate to observe that the setting aside of the orders impugned in the instant proceedings by this court shall not preclude the department to take such action as deemed proper in terms with the rules of 1964. This matter has been pending since 2012.
Yes.
Item number 4 to 6 for hearing.
Yes, what is your case?
My lord, matter pertains to VRS benefit, my lord. Item 4 and 6 are regarding Kasar Sugar Mill Limited, my lord, and item number 5 is regarding Assam Cooperative Sugar Mill Limited, my lord. My lord,
Item number 4,
4 to 6. My lord, kindly
5
take the,
and 6.
my lord, kindly take the item number 6 first, my lord.
Okay, item number 4. Yes, what is this matter about?
My lord,
What are you asking for? Let us see. To recalculate the retirement benefits by giving up-to-date revision up to 1998 and taking the age of superannuation at 60 to the petitioner and pay them all further benefits. Fantastic. Now tell me.
my lord, the Kasar Sugar Mill was closed, my lord, in the year 2009, notifying with effect from
Kachar Sugar
Sugar
Mill.
Mill Limited.
Okay.
My lord, petitioners are ex-employees of Kasar Sugar Mill Limited, my lord, under the AIDC. My lord, in the year 2009, the authority management has communicated us that the Kasar sugar mill has been closed and offered VRS benefits. So accordingly, we preferred for VRS, my lord. Some of benefits has been given, my lord. Sometime in the year 2009, my lord, the authority has not given revised scale of pay. The authority has calculated our VRS benefits on the basis of the third wage board, which was effect from 1988, 1st of January 1988 for 5 years, my lord, which is effect till 1992. On that basis, the authority has given us VRS benefits in the year 2009. In other hand, my lord, some of the employees of Kasar Sugar Mill Limited has accepted the salary pattern of the AIDC, my lord. That employees has been given.
Mr. Counsel, wait. You have got your VRS.
Yes, your lordship.
VRS is based upon a particular golden handshake.
Yes, your lordship.
Now, where is the VRS?
My lord, scheme I have annexed here, my lord, at page 22.
Okay, now what is this VRS business out here? Revised policy on voluntary retirement of for employees of the state level public sector. Okay, now what are you not getting?
My lord, I have getting VRS on this scheme, my lord, on the basis of the wage pattern prevail in the year 1992, my lord.
You want as per 2006.
Yes, your lordship.
Where is it? Ex gratia 15 days payment, cash payment, balance of contributory, so and so, basic plus DRS allowance only against each completed year of service rendered on or before so and so. I mean, one are to be closed or revived or whether so and so can be and so, excluding the assumption that gratia of 15. So you say, when was your VRS accepted?
My lord, sometime in the year 2009, my lord.
Okay. Now, while accepting it, did you? But your meal was closed from 1/4/2007.
With effect from my lord.
Okay. Now, while accepting, when you accepted this particular amount, it is Annexure 5, page 30.
Yes, your lordship.
These are the VRS dues.
Yes.
Date of release, these are all released sometime on 2007. Some are released on 2003. All the petitioners herein have retired.
My lord, till closure of the mill, not retired, my lord, all. Some of employees has retired prior to the closure of the mill, my lord. I am not claiming on that employees
Who retired?
who retired.
You are those persons who were there at the time of closing.
Yes, your lordship.
So you are saying that the salary has to be made or fixation of this 15 days ex gratia payment has to be made on the basis of the scale of pay which was as on 2006.
Yes, your lordship.
Okay. Now tell me, this ROP 2006, 1/1/2006 is the date or 1/4/2006, whatever may be. Was it extended to this corporation?
Yes, your lordship.
Show me that.
I have annexed the document in item number 6, my lord.
Which one? 6072?
Yes, your lordship. 2022.
2000?
22 meter, my lord. Here,
Yes.
my lord, I have annexed Page 50, my lord. Annexure 12.
Yes. Directed to
yeah, my
inform
lord.
that the government of India has approved your proposal for revision of so and so. Further, you are informed the additional burden on account will have to be generated by the AIDC from its own source. So this was done in 2012.
Yes, your lordship.
Now, was it given effect from 1/1/2006?
Actually, my lord,
No, lordship, if your lordship recollects, the similar matter has come before your lordship. The same thing, lordship, same VRS scheme, and this ROP was earlier also prayed for, that lordship has already rejected that, like, this will be applicable because it was not accepted or extended by the state government. It is only after 2012, lordship. So that is not going to cover them because VRS scheme was in 2006 and it was given effect on 2007. And it was specifically stated, it was stand of the government that.
No, I'm only asking.
Lordship.
The ROP rules of 2010 was approved by the state government. There was a specific order
Correct. Lordship.
so that the AIDC people gets it.
Get it.
Now, these are corporations. They are automatically with the ROP, it does not happen. So the corporation has to also decide,
Adopt it, Lordship. Correct.
adopt from the date.
Date.
When is the date?
No, it was not adopted. It is ROP is not because they are already been closed.
Which
And
one?
they have been given as per the VRS, they have VRS scheme, they have been given the pay scale on the basis of the pay prevailing at that point of time. This ROP came later on. So Lordship has already, Lordship, if your Lordship looks into this case, Lordship has already decided on this matter.
My lord, there is a two class of employees. There is a right, my lord. Two class of employees. One getting the salary pattern of the AIDC. Others getting the West Board salary, my lord.
But that is also not adopted, Lord.
Because of this, my lord,
18.
our problem arises, my lord. The AIDC.
No, Mr. Counsel, first and foremost,
Okay.
have you seen the ROP 2010? You have a copy of the ROP of
Sorry,
2010?
my lord, right now I have not.
Without the ROP of 2010, how are you arguing? Clause 1B stipulates that it will be effective from 1/1/2006 for the purpose of the government. No problem.
Yes, sir.
But clause 2 says, or rule 2 says, for those corporations and all these things, there has to be a specific order from the government.
Yes, sir.
This order came only in 2012.
Well,
So was it made applicable from then?
yes, as per the my lord scheme, it stated up to that ROP, my lord.
So this aspect, therefore, I have decided that there is no material placed on record to show that the government by any express order have extended the Assam so and so to the officers of the Assam State Textile Corporation, which is an undertaking of the government. Under such a position of applying does not arise, and consequently the members of the association cannot be held to be entitled to the area salary as per the revised scale of ROP with effect from so and so to so and so.
That will say, Lord.
Then that is the problem. You are arguing a matter without knowing the scope of rule 2. I'll show it to you. You need to prepare your matter properly, Mr. Counsel. Hey, rule 2 say application of the rules.
Yes, Lord.
Save as otherwise provided by or under these rules. These rules shall apply to all employees appointed to services or posts in connection with the affairs of the state of Assam and which are under the rule-making control of the governor of Assam. You are not. Unless specifically extended under express order of the government, these rules shall not apply to you come within the ambit of
5.
Officers and staff of public undertaking of the Assam
Yes,
government.
Your Lordship.
5.
Yes, only my lord, annexure, I have drawn attention, my lord.
To Annexure 12. That was in 2012.
Yes, Your Lordship.
So unless you show that it was given effect to,
Yes, Your Lordship.
I'll help you.
Yes, my lord. Regarding my lord 2013 meter 807 of 2013, here I have claim only the 98 ROP, my lord. Which was
That you
effect
are
from,
98 ROP only.
yes, my lord.
He is entitled to the 98 ROP.
Yes, my lord.
Are you not getting your amount?
No, my lord. That's why I am
They
saying that
gave you
there are
what? 76.
class of employees, my lord. One, getting the AIDC pattern of scale has get the benefits under the ROP 98. But others, the petitioners of this petition has not getting up to the 98 ROP, my lord.
Right?
Because, my lord,
Your prayer in the first petition
yes, my lord.
is as per ROP of 2000. That is not your prayer.
Yes, my lord.
By giving up-to-date revision of pay of 1998 and taking age superannuation as 60 to the petitioners and pay him further. All benefits consequential. So
Yes, my lord.
are they not entitled as per the 98?
The lordship, for 98, they're entitled, they're getting, what he is saying that there's a sugar mill waste board. The sugar mill waste board gives some certain guidelines point to point in certain points of time. Now, what happens is like the Assam government hasn't adopted that. Assam government is like they are under AIDC rules. So as per the AIDC rules, they have been given the pay package. And under that VRS rule has been framed and they have been given that.
Good, but then if they are under, as you say, under the AIDC, then AIDC for those people, they will be entitled, calculation has to be made as per the ROP 1998.
That has been made.
That
No,
is
my
not
lord.
fair.
Has been made.
No, my lord. Who
That has
have
been
getting
done.
the salary on the pattern of waste board has not getting the benefits under ROP 1998, my lord. Only those employees who getting the salary in the pattern of AIDC has got. We have not.
Now the petitioners herein are getting the salary as what?
Benefit has been given on the basis of waste board tree, which was effect till 1992 only, my lord. We are getting salary up to 98 on the basis of following the pattern of UP.
Now you are saying at paragraph number 3
Yes, Lord.
that the sugar industries in India are governed by the rules framed by the Central Sugar Wage Board. Accordingly, the petitioners were getting the scale of sugar. Petitioner being the central sugar stakeholder are given only one revision of scale in 1998. Although successive revision of pay implemented in other sugar factories within India in the line of UP pattern wages meant for sugar in northern zone, the third wage so and so for Iman, which specified benefits of sugar industry employees. The management of so and so also accepted and implemented the award of the UP pattern before 1998 and benefited for UP pattern out and paid to the Kachar. Thereafter, up to so and so, superannuation has been fixed, but while granting the retirement benefit to the others, including the VRS, there is without considering up to state revision of pay and age of superannuation of 60 years granted the benefit to the petitioner. You mean the up-to-date revision of pay in terms with the sugar,
Sugar
sugar
mill.
board,
Waste board, my lord.
sugar wage board?
Yes, your lord.
That has not been given to you.
As per waste board given, my lord, but not as per 1998 ROP, my lord.
At that time of calculation, Lordship, 1998 is there, Lordship. And
Very good.
therefore, yes, Lordship.
You have filed an affidavit.
Yes, Lordship. In my affidavit, para 6, I am categorically stated, Lordship.
There are 3,
Para 6,
there are 5.
affidavit
Deponent respectively,
on
there
behalf
are
of
two
two
categories of permanent employees in the mill. One consists of 22 employees and have accepted the state government AIDC pay scale, and the other consists of 122 employees who accepted the sugar wage board. The management of the mill had followed both the revision of pay scale of the government as per the ROP 1998 and the third year carefully, and dues were calculated as per the month and the year, which was the latest available wage board till 1998 respectively. Accordingly, after calculation of the area scales, so and so, the same were submitted before the government for approval and release of funds. Thereafter, due payment was made to the employees, including the petitioner, after release of funds by the government, and while receiving the benefits, the petitioner employees inter alia submitted individual undertakings to the mill to the effect that they have no further claim. Further, the dues, including the area salary so and so, were calculated up to the month as per the closure notice dated on, and accordingly the notice was duly published and payment was released, and therefore the payment of area salary till so and so does not arise. Have been considered as no revision was made in the year under the with the pay scale of the employees under central pay had not been considered, as no revision was made in under the central as per the records available. Age of superannuation in respect of the closed units have been considered as 58 years, and accordingly the same has been considered by the deponent while calculating the fines. So here, on one hand, at paragraph number 5, you are saying that there were 22 employees who accepted the AIDC.
AIDC, Lordship.
The second is as regards 122 employees who
Sugar
were
wage
under
board.
the wage board.
Yes,
You are saying that you have given them the benefit under the third wage board.
Lordship. Regarding the AIDC employees.
No.
This
That's
one,
122 person.
yes, Lordship. Yes, Lordship.
You are giving as per the third wage board. Now, here at paragraph number 3 of the writ petition, so are you giving as per annexure 4, page 27 of the writ petition?
Lordship, regarding the salary, Lordship, this is given under the benefit of the sugar wage board, Lordship.
So this is annexure 4.
'89. And this one.
Yes, my lord. As
Yes,
per that
89.
report I got.
89.
We have received on that basis, my lord,
On the basis of this one,
that return, my lord.
you have received it.
Yes, your lord.
Only problem is the age.
Is,
At 18, it is said that the age has to be 60 years.
yes, your lordship.
So
But we have been provided up to
58.
58.
Okay. Now, why 58?
58, in that time, Lordship, all the employees, Lordship, state government employees, all the employees come under 58 years, Lordship. It is as per the Employees Provident Fund and Miscellaneous Provisions Act 1952.
No, my lord.
Yes,
Where did you get that?
yes, this one.
But isn't it the year of 2005 when they changed the age from 58 to 59 and 59 to 60 for state government employees?
Yes, my lord.
At that time, Lordship, it is on 2009, Lordship. 2009, Lordship, it is 58.
Lord, in this regard, I have annexed the notification, my lord, of the Department of Personnel.
Why you are doing it under the Employees Provident Fund and Miscellaneous Provision Act?
In regards to the state government employees, Lordship, is 58 is adopted at that time. Lordship.
Where is that notification?
My lord, I have filed and reply to the affidavit filed by the respondents, my lord. And at page 4, Annexure 14, page 82 of my affidavit in reply.
Where?
In my writ petition 6027 of 2022.
Annexure?
Annexure 14, page 82. My lord, it is stated the age of
58
retirement.
to 59 years. This is in 2005, if I remember correctly. Then
Next paragraph, my lord. Grade 4 employees and other state government employees who are at present entitled to serve up to the age of 60 years, including the new entrants, will continue to be 60 years.
which one?
My lord, second paragraph.
The age of retirement of grade 4 employees and other state government employees who are at present entitled to serve up to 60 years, including the new entrants, will continue.
Yes,
So
sir.
you are 60 years. You are grade 4.
Yes,
All are grade
we
4.
all are grade 4 employees.
Yeah.
Other employees of the AIDC Lordship, they are not coming to the court Lordship. They got their
Concerned
benefit.
about grade 4.
58 Lordship.
For them, I'm not concerned. I'm concerned with grade 4. They are grade 4 all
Yes, my lord.
petitioners.
No, that
Only one, my lord,
I
in
don't
the-
think
in this
the petition
2022
Lordship in
writ
the
petition, my lord,
writ
only one
petition it
grade
is not
3.
reflected Lordship.
Let one person say. Yes. Are all the petitioners grade 4?
Yes, your lordship, in the 2013 writ petition, all the petitioners are grade 4 employees.
Now, which are the petitions? Now, this is in 2022.
One 2022 and another is 2013.
22 all are
My lord, in 22, only one employee, grade 3 employee.
grade 3.
Yes, your lordship.
And these employees in 2023, these persons
Yes,
are claiming what?
my lord, in this writ petition, we have prayed which were skipped from the 2013 petition, my lord. That is,
Now you are, in this case, you are asking for ROP 2010.
10 also, my lord.
Are these the petitioners the same in 2013 in here?
Not all are, my lord. Some
So
of
some
the
are
peti-
same.
Yes, my lord.
So are you saying that in one writ petition you are asking as per 1998 and one you are asking for 2010?
My lord, I'm praying for on the basis of only annexure 12 of my writ petition, my lord.
Mr. Council.
Now, my lord, I am pressing only 98, my lord, because
So you are withdrawing this 60727?
my lord, here another prayer are also there, my lord. That is for house rent allowance and medical allowance, my lord. For house rent allowance and medical allowance also, I have prayed, my lord.
House rent allowance and medical allowance.
Yes,
Are
your
you
lordship.
entitled as per the VRS?
Yes, my lord. Other PSUs has getting, my lord.
In some order, I have seen, I have given house rent and medical allowance. That was after Justice Vaipai's order.
Yes,
That
your
is,
lordship.
that is,
That is
that is the
here.
order.
Ah,
The house rent allowance, medical allowance, and city allowance, if they are entitled, city allowance. These three lordship is,
so there you are going to get it.
Yes, yes.
Okay.
that's it.
Now 6027, otherwise you have no case.
One more thing, my lord. I am stating in this writ petition that we are working till July 2008. But the authority declared as closed with effect from 1st of April 2007. I have annexed attendance
They have
register
already
also.
accepted VRS, Lordship.
When did you accept the VRS?
Now they cannot raise
My
after
lord, VRS benefit-
2009.
VRS
after so many
benefit
years.
provided to us in the year 2009, my lord.
I'm not on the benefit.
Yes, my lord.
Did you submit your application?
Yes.
You have accepted. If you see, it will, the date on which you has been accepted, kindly see from the VRS scheme.
In this regard, my lord, I like to draw attention to page 49 of my
Basic
report.
pay and rate of DNS allowance shall be taken and as on the date of application by the employee opting for the VRS and the date of closure of the SLPE, whichever is applicable. No request for any revision shall be entertained thereafter.
My lord, kindly have a look at page 49 of my repetition, annexure 11. Here I have annexed the letter, but this letter has not been mentioned to whom issued, but who issued has been reflected, my lord. Here it's stated, as per decision of the state by notification number so and so, 2nd of April 2008, the government of Assam decided to close the Kasar Sugar Mill Limited. This letter issued on 18/12/2008, my lord.
To whom?
That is not mentioned, my lord.
My goodness, how did you get this document?
This this document is.
My lord, it's provided to the
Who is the-
association, but
No, no, no.
not mentioned the,
Obviously, that
Address.
is why he has not given the name.
Yes.
It's of no use.
but content, my lord, content
No, no,
reflects,
this is
my
not a
lord. That's
valid
why I am-
document. Lordship.
No, but Mr. Counsel, I don't understand why you are keeping on filing the same petition once again by the same petitioner.
My lord, actually, since 2013,
That petition has not been disposed
waiting, my
of.
lord. But
That is why I filed another petition.
no, my lord, later on came to know that some prayers is skipped out, my lord.
So that is why. So instead of that, why didn't you go for amendment there? But filing again, asking now, there you are asking on 98, now 2010.
That part, my lord, maybe skipped out, my lord.
Okay, what is the second petition for?
Second, my lord,
2017.
item number 5 is also in similar footing, my lord, but here under the cooperation department, my lord, not the AIDC, my lord. That is with, I have got relief that benefits under West Board 3, my lord, not the ROP 1998,
Different from those two.
my lord.
This item number 5 is different from the earlier one.
Yes, Lordship. Early,
So this matter has no relation with those two.
My lord, have some relation because same thing, my lord, West Board 3, as per West Board 3, we have been provided the VRS benefits, my lord.
Understood, but is this the same sugar mill?
Another
no,
sugar
Lordship,
mill, my
no,
lord.
Lordship. The
Another sugar mill, my lord. Assam Cooperative Sugar Mill Limited, my lord.
Assam Cooperative Sugar Mill.
Yes, your lordship.
N6, Lordship.
Here cooperation department, my lord.
Fantastic. So let us do one thing. Leave this matter aside
Yes, your lordship.
and dictate the judgment. Yes, your name?
M. Soikia, my lord.
Mr. M. Soikia, the learned counsel for the petitioner. Mr. Petitioners, Mr. A. Kolita appears on behalf of the respondent number 1. Mr. J.K. Goswami appears for the respondent number
2, 3, and 4. Lordship.
2 also.
2, 3, and 4. Lordship.
2, 3, and 4. And public enterprise, you. A. Kolita appears for respondent number 1 and 5. Mr. J.K. Goswami appears for respondent number 3 and 4. And Mr. P. Nayak appears for the finance department. Respondent number 6. Both the repetition the facts in both the repetitions being similar and the question of law involved are parametric. both the writ petitions, therefore, are taken up for disposal by this common judgment, by this common order. The facts of the instant case is that the petitioners herein but 60 years, what do you say on 60 years? How do you escape that?
Lordship, regarding that, Lordship, so far letter of the personnel department, Lordship, and in that, Lordship, it is stated that regarding the fourth grade employees versus 60 years, but from the perusal of the writ petition, Lordship, and so far in the list which is in my hand, I submitted in my affidavit, Lordship, in item 6, Lordship, I categorically submitted the list of the employees. More or less, some petitioners are not belongs to the fourth grade, Lordship. It is stenographer is there, Lordship. Electrician is there, Lordship. These are not chemist is there, Lordship. These are not the employee of the fourth grade, Lordship.
Mr. Goswami, those people who are not there, they are third grade. Their age is 59. How do you take care of that?
We adopted at that time, Lordship, the state government.
No, all of a sudden from Employees Provident Fund, why are you bringing the Employees Provident Fund when the age out there of the state government was 59 for those people, because in 2005 it was 59 and it was kept at 60 only for the grade 4.
It may interfere.
So that portion you need to calculate.
Yes, sir.
Yes, Mr.
One clarification is there, Lordship. In item number 6027, Lordship will kindly see paragraph 4, Lordship. Lordship, there they have mentioned that some people got the benefit up to 60 years, but some were not given that benefit. But that distinction they have already made, Lordship.
So therefore,
Those
we'll
who,
verify.
the employees, those who are under AIDC, Lordship, they failed to get the benefit of 6 years, but persons who were under sugar board, wage board, Lordship, they got the benefit of 6 years.
Whatever may be, but if they were under the AIDC also, if they were grade 4, they were entitled to.
They are not coming before the court, Lord. AIDC employees, Lordship.
Those 22 are not before the.
Yes.
So we are only concerned with.
Only concerned with the wage board employees, Lordship.
So these are 122 then. All these petitioners are come within the wage board.
Yes, in that case, Lordship, that 2010 will not be applicable for them.
No quarrel.
That is only prayer here, Lordship.
No. That has already been negative. That I am dismissing it on those aspects. But I'm only saying that their age couldn't have been taken at 58. Because not only those people who are grade 3, in the year 2005, the age was increased from 58 to 59. Grade 3. But grade 4 was 60 at that point of time and now also at that point of time. Now I don't know how much.
My lord, in 22 writ petition, some employees are there, my lord, who have getting salaries under the AIDC also, my lord. And my lord, Asutosh Sharma, as I know, my lord, he is getting salary and benefits under the petitioner number 22
Of which petition?
of 2022, my lord, 6027 of 2022, my lord.
So he is getting from?
He is getting the VRS benefit as per salary pattern of the AIDC, my lord.
Whatever may be.
But that statement is not.
Your thing will be 1998.
Yes, my lord.
You can't escape from that.
Yes,
They will give. Now, if it was taken as 58 years, that was wrong. It should have been taken as 60 years if he was a grade 4. But if it's a grade 3, it will be 59 years. So that aspect, the authorities will verify.
No, that distinction they have to make, Lordship. Here, Lordship will get no statement that I am covered by the wage board salary or I am covered by the state pay commission. That distinction is not here. In the list given by the AIDC, there they have only mentioned that 20% were under AIDC, remaining were under sugar board, wage board, Lordship. But where from Lordship will get the fact that which petitioner belongs to which category? That is not there.
No, in their affidavit, they have categorically mentioned that 22 persons are from the
22, yes,
AIGC,
that figure is there.
and 122 is from the person of whatever means. Now, the question is out here that this court is not going to give them the 2010 wage board. No, nothing there. This court is limiting the whatever calculation has been done as per 1998, which they have stated that will remain as it is. But only as regards the age. That aspect has to be taken note of. The authorities will have to take a decision on that. I'm not on the other aspect.
Then they will verify and confirm.
That is what
Yes,
I'm
sir.
saying all
Yes,
along.
Lordship, yes.
My lord, regarding salary also, I may not be placed properly, my lord. I am claiming that who have getting the salaries as per the pattern of wage board has not got benefit as per 98 ROP, my lord. They are paying for as per 98. My lord, in this regard, I may not be clear, my lord. I like to draw attention to our representation. I have annexed
No,
in
no, no,
WPC
Mr.
number
Counsel,
2013, my lord.
wait a minute. Now it's another different thing you are bringing. You are saying that if you see paragraph number 3 of your petition, the first one. Read it.
Yes, my lord. That your petitioner states that sugar industries in India are governed by the rules framed by the Central Wage Board. Accordingly, the petitioners were getting the scale of Central Wage Board scale. The petitioners, being Central Sugar Wage Board scale holder, are given only one revision of scale of pay, with effect from. My lord, actually, it is wrong, my lord. It is not correct, my lord. It is 88, my lord. 88. Wage Board 3 is affecting from
Further
1988.
read it, Mr. Counsel.
Although successive revision of pay implemented to the sugar factories within India in the line of UP pattern of wage mean for sugar factories in northern zone, the third wage board for sugar industries which specified benefit of sugar industry employees, the management of Kasar sugar mill also accepted and implemented the award of UP pattern of wage before 1988 and benefit as per UP pattern of wage worked out and paid to Kasar sugar mill workers. Thereafter, up to that third Central Wage Sugar Wage Board awarded superannuation age has been fixed 60 years, but while granting the retirement benefit to the petitioner under including the VRS, the respondent authorities without considering up to date revision of pay and age of superannuation of 60 years granted the benefit to the petitioners, my lord.
Only 60 years.
That is, my lord,
So
without granting, my lord.
have not considered what your specific case in paragraph number 3 is very clear. And look here, this was there is a wage board recommendations, and if you have seen it, annexure 4 of your writ petition, more particularly at paragraph 27, page 27, you will see that is as on 1989.
Yes, your lordship.
So that is what you are claiming out there.
My lord, my lord, but the scheme through which VRS benefit has been provided only one, my lord, that is issued on 15th of February 2006. Under one scheme, two categories have getting different benefits for service providing same standard, my lord.
Long going on. You have accepted with your open eyes. Then why should this court interfere? Tell me. I can't help you with this. I can only help you with the age, nothing more than that. And medical and city compensatory and the other one, house rent allowance.
House rent allowance.
That's all, nothing further beyond. Heard Mr. M. Soike, the Learned Counsel, appearing on behalf of the petitioners in the two petitions. Mr. So-and-so, J.K. Goswami appears on behalf of the Assam. Hey, ago ekita lekha hoise. The issue involved in the instant writ petition, in the present writ petition, pertains to as to whether the petitioners would be entitled to the revision of pay in terms with the Assam ROP rules 2010. As well as other benefits as claimed in the writ petition. It further transpires from a perusal of the writ petition that it is the case of the petitioners that in terms with the wage board recommendation, the age of superannuation was 60 years. And also, as per the government circular, government of Assam circular, dated 25th of January 2005, issued by government of Assam's office memorandum dated 25th of January 2005. The age of retirement of grade 4 employees was 60 years, whereas of the other employees was enhanced from 58 to 59 years. It is therefore the case of the petitioners herein that while settling the VRS entitlement of the petitioners, they have been deprived on the basis of not calculating their entitlement on the basis of the basis of not calculating their entitlement in terms with the Assam revision of pay rules 2010, as well as also not calculating their age of retirement as 59 years or 60 years, as the case may be, for grade 3 and grade 4 employees respectively. At this stage, it may be relevant herein to mention that a few of the petitioners who were there in WPC number 6027/2022 were also the petitioners in WPC number 807/2013. The prayer made in the said writ petition was for recalculating the retirement benefit by giving up-to-date revision of pay of 1998 and taking the age of superannuation as 60 years to the petitioners, and to pay them all further benefits consequent thereto. This court has made a specific query upon the learned counsel for the petitioner as to why two petitions were filed. By the same set of petitioners, except a few who have been left out in the second litigation. The learned counsel for the petitioner submits that in the second writ petition, the claim of the petitioners is on the basis of the Assam revision of pay rules 2010, and also as certain claims pertaining to medical allowance, house rent allowance, and city compensatory allowance have not been paid. Such claims have been duly included. Next. Let this court first take into consideration as to the entitlement of the petitioners in terms with the Assam revision of pay rules 2010. The petitioners herein admittedly were employed in a public undertaking of the government of Assam. It is relevant to take note of that on 4th of February 2010, a notification was issued by the government of Assam Finance PRU Department thereby notifying the Assam Service bracket Revision of Pay Rules 2010. Although, in terms with Rule 1B of the said rules of 2010, the same way, it was brought into effect on 1st of January 2006. But in terms with Rule 2, it was categorically mandated to, it was categorically mentioned in Rule 2B that unless specifically extended under express order of the government, the rules of 2010 shall not apply. To officers and staff of public undertakings of the government of Assam. A perusal of Annexure 10 of in WPC number 6027 of 2022 shows that it was only on Annexure 10 on Annexure 12 of WPC number so and so shows that it was only by the communication dated 26th of September 2012, the Joint Secretary to the Government of Assam, Industries and Commerce Department, had informed the Managing Director of the Assam Industrial Development Corporation Limited the decision of the government in the Industries and Commerce Department approval to the proposal for revision of pay scales of the employees of AIDC Limited as per the Assam Service ROP Rules 2010. From a perusal of the same document, it, however, does not appear as to whether the Assam Service ROP Rules 2010 was extended to the Assam Industrial Development Corporation Limited with effect from 1/1/2006 or such other date other than 26/9/2012. Therefore, by virtue of Rule 2B, Roman 5 of the Assam Service ROP Rules 2010, and upon a perusal of the communication dated 26/9/2012, this court is of the unhesitant opinion that the petitioner herein cannot claim the recomputation of their VRS entitlement on the basis of the Assam Revision of Pay Rules 2010, Assam Service bracket ROP Rules 2010. Next. Now coming to the question as regards the entitlement of the petitioner. Petitioners. On the basis of revision of pay of 1998 as claimed in WPC number 807 of 2013. In the same petition, an affidavit has been filed by the Managing Director of the Kachar Sugar Mills, who have been implemented as a respondent number 2 and 3. A perusal of the said affidavit discloses that there were two categories of permanent employees in the Kachar Sugar Mill. One group consists of 22 employees and have accepted the state government oblique the AIDC limited pay scale. And the other consisted of 122 employees who had accepted the Sugar Wage Board pay scale. It has been further mentioned that the management of the Kachar sugar mill had followed both the revisions of pay scale of the government of Assam as per the ROP 1998 and the third Sugar Wage Board carefully, and dues were calculated as per the ROP 1998 in respect to those employees who accepted the state government oblique AIDC limited pay scale and the third wage board scale in respect to those employees who accepted the Sugar Wage Board pay scale. It was further mentioned that after calculation of the area salary, gratuity, VRS, etc., the same was submitted before the government for approval and the release of the fund. Thereafter, due payment were made to the employees, including the petitioners, after release of the fund by the government. And while receiving the benefits, the petitioners oblique the employees inter alia submitted individual undertakings to the mills to the effect that they have no further claim on any amount whatsoever. It has further been mentioned that the dues including area salary, gratuity, leave salaries, VRS were calculated up to 31/3/2007 as per the closure notice dated 27/4/2007. And accordingly, the notice was duly published and payments were released, and therefore the payment of area salary till the year 2009 did not arise. In paragraph number 6 of the said judgment, said affidavit, it has been further mentioned that a pay scale for the employees under the Central Sugar Board pay had not been considered as no revision was made in the year 1998 under the Central Sugar Wage Board as per the records available with them. It was further mentioned that the age of at this stage, if this court takes note of the writ petition, more particularly Annexure 4, it is seen that the petitioners have claimed on the basis of the report of the third Central Wage Board for Sugar Industries dated 31st of January 1989. Therefore, this court finds no ground to interfere or pass or issue a writ in the nature of mandamus directing the respondent authorities to recompute the salaries on the basis of the revision in view of the specific stand being taken by the by the respondent number 2 and 3 in the affidavit, to the effect that some of the employees have been given, the sum of the employees who were accepting the AIDC pay scheme were given their entitlement were calculated on the basis of the revision made in the year 1998 by the state of Assam. And those employees who had accepted the Central Wage Board pay were also granted the benefit in terms with the third wage board, Sugar Wage Board recommendations. Now the next question therefore arises as regards the entitlement of the petitioners, taking into account that it is an admitted stand taken by the respondents number 2 and 3 in the affidavit that a computation of the entitlements of the petitioners were made on the basis of the year 1990, on the basis of the age of superannuation at 58 years. The Learned Counsel, appearing on behalf of the petitioner, submitted that in terms with the third Sugar Wage Board recommendation, and more particularly at clause 18, it has been categorically mentioned that the age of superannuation was fixed at 60 years, which was duly accepted by the respondent number 2 and 3. The Learned Counsel further submitted that this aspect of the matter is further clear from their own affidavit, wherein also they accepted that they had paid the salary or calculated their entitlement on the basis of the third wage board recommendation. The Learned Counsel for the petitioner further drawing the attention of the office memorandum dated 25/1/2005 have also drawn the attention to the effect that the age of superannuation was increased from 58 to 59 years with effect from 1/1/2005 in respect to of all other employees, and in respect to grade 4, the age of superannuation was 60 years. It is therefore the stand of the petitioners herein that the petitioners' entitlement should be taken into consideration by taking into account the age at 59 years if those employees were grade 3 employees, and 60 years if those employees were grade 4 employees. Upon hearing the Learned Counsel for the petitioner as well as the respondents, this court is also of the opinion that taking into account clause 18 of the third wage board recommendation, which categorically mentions that superannuation age to be 60 years, as well as the office memorandum of the government of Assam, which stipulates that for grade 4 employees, the retirement age to be 60 years. And for other employees to be 59 years. The petitioners have been able to make out a case for recomputation of their entitlement on the basis by taking into account their age to be 59 years and or 60 years as the case may be, depending on whether they were in grade 3 or grade 4 services. This, however, would require a verification to be made by the respondent number.
Yes, respondent 2, 3, and 4.
By the respondent numbers 2,
3, and 4.
2, 3, and 4.
Lordship.
In WPC number 807/2013. The Learned Counsel, appearing on behalf of the petitioners, further have submitted that this court in another writ petition while dealing with the same VRS scheme, that is in the case of Assam Rajyik Vastra Nigam Karmachari Santha and another versus the state of Assam and 4 others, WPC number 2633/2014. By judgment and order dated 5/1/2023, had directed, had observed that similarly situated persons like the petitioners would be entitled to medical allowance as well as house rent allowance as a part of their salary. The learned counsel for the respondents, particularly the respondent number 1 to 5, 1 and 5. Had submitted that this court, along with other court-made benches, have also held that the medical allowance as well as the house rent allowances to be a part of the salary while computing the entitlements. In that view of the matter, this court, taking into account the judgment and order dated 5/1/2023 in WPC number in the case of Home Rajik Boston Nigam so and so Supra, further observes that the petitioners herein would also be entitled to further observe that while computing the salary of the petitioners, the medical allowance as well as the house rent allowance shall also be taken into consideration. Accordingly, the instant both the writ petition stands disposed of with the following observations and directions. Number 1, the petitioners are not entitled to the salary, entitled to claim their entitlement on the basis of the Assam Service Rules, Revision of Pay Rules 2010. Number 2, the petitioners are not entitled to recomputation of the entitlement on the basis of the revision as revision. The petitioner is not entitled, is entitled to the recomputation of the salary by taking into account their age of superannuation to be 59 years for grade 3 employees and 60 years for grade 4 employees. And in that regard, the respondent number 2, 3, and 4 shall make necessary verification to that effect and recompute the same within a period of 3 months from the date of submission of a certified copy of the instant judgment and order. Number 3. The respondent number 2 and 3 and 4 is further directed to recompute the entitlement of the petitioner on the basis of the salary by taking note of that the medical allowance and the house rent allowance shall form a part of the salary. Petitioners, the petitioners such exercise be completed within the period above mentioned in clause number 2. There's 2 over, no, itu. There's 2 here in above. Number 4, 3. The petitioners are not entitled to the claim as regards recomputation of the salary on the basis of the revision of pay of 1998. Other than what have been already given to them in as stated in the affidavit in opposition filed with respondent number 2 and 3, as already mentioned here in above. In the present facts and taking into account the fact involves, taking into account the the facts involved, this court is not inclined to impose any costs.
Lord, item number 5 may be taken up. May I prefer taking up on Friday, my lord?
I'm coming in 5 minutes. Then I'll
Malad.
consider your request. So what is your case here?
My lord, in this matter, my lord, the petitioner is ex-employee of Assam Cooperative Sugar Mill Limited, my lord. The Corporation Sugar Mill was sick since 1996, and since 96, the petitioner and other employees has not getting their salaries. In the year 2008, they have approached the Honorable Court filing a writ petition, my lord. By WPC number 1930 of 2008. In this writ petition, the Honorable Court directed the respondents to take a decision whether the mill have to revive or close. But nothing has been done, my lord. Because of that, the petitioner approached again and reopened the writ petition. Then, during that pendency of the writ petition, the respondent has given some benefits, my lord. But later on came to know that the calculation was made on the basis of Central Waste Board 3, my lord, not as per prevailing ROP, my lord. In that case, my lord, the petitioner has approached
First of all, tell me whether you were getting the salary as per the wage board or what.
Waste Board, my lord.
Then what is this revision business on the
My lord,
ROP then?
I am claiming Waste Board regarding ROP because, my lord, Waste Board were not existing after 92, my lord.
So I can't
State
help
government
you,
have
but
to
you
take
were all
decision.
along. Mr. Kusaikia,
Yes,
the thing is, you were given a particular salary all along, you were happy with that salary.
my
Yeah.
lord.
Now, pursuant thereto, you have accepted the golden handshake
Yes, my lord.
happily, unhappily, whatever you mean. After doing so, this happened in 2007.
It was around about 2009, my lord.
2009. Then all of a sudden, the petitioners got hold of you
Yes, my lord.
and you gave them an idea, why not try your luck under the Fifth Pay Commission?
My lord, because if decision, my lord, for providing same service, one getting 3 times greater than me, my lord. Because of that, I'm
Understood, but why didn't you agitate that point at any point of time earlier?
my lord, I
That
have
your
raised.
salaries were given less. Did you ever agitate at the time when you were getting the salaries when the mill was functioning properly? That look here, we should be given as per the Assam ROP, not as per the wage board. Did you ever hesitate that? Then how can you are given a golden handshake on the basis of what salaries you were getting?
that
Then
is I
how
have
can you
not
get
done.
something else?
Yes, your lordship.
I'll
During
help
that
you.
period, prior to 1996, I have not raised that.
Understood. If earlier to that,
Yes, ma'am.
you were all along fighting that look here, we are entitled as per the ROP, not as per the wage board thing. Fair. It's a fair submission. This court would have. But you have not done that. You have accepted the VRS. In the earlier matter also, here also, it is apparent from the affidavits out there that you have accepted it.
Yes, my lord, but after getting the benefits, I came to know that we have been provided on the basis of that wage board, which is not.
But were you ever getting your salary as per the ROP?
No, my lord.
Then
I am claiming only because, my lord, the wage board has not been existing after 92. After 92, my lord, we have been provided benefit in the year 2012. And the wage board was existing till 92. After 20 years, my lord, 20 years back, what was given on that basis, after 20 years, given benefit to me. And other employees has been given on the basis of the current rate of salaries, my lord. That's why, my lord, when the wage board has not continued, My lord, I have not annexed the here document because I have not able to acquire, my lord. Central government declares that they will not continue with central wage board. Because of that, UP has formulated the salary pattern. Because in North India, there are so many sugar mills. And because of that, as in Assam also, my lord, accepted that pattern and accordingly provided salaries on the pattern of the UP, my lord, to the Kasar sugar mill, which was already decided, my lord. And
But here that aspect was not done.
yes, my lord, we have been given on that basis, my lord, but I am not stating specifically because we have not getting salary since 1996. But the Kasar sugar mill getting their salaries till 1998. That since 96 to 98, they are getting on the pattern of UP, my lord. But here I
They
am
were
not-
getting as per in Kachars, which I've disposed of, they were getting as per the UP rate.
yes, your lordship.
However, that UP rate has not been given to you.
At that time, my lord, since 96, the mill was sick, not able to provide salaries. Because of that, they have not adopted anything, my lord. And government of Assam has not been formulated salary pattern for us, my lord. Because of that, we are claiming the prevailing salary pattern, my lord. Not because of any other reason, my lord. If the wage board continues, then we have no problem. We are ready to getting, we are happy to getting that pattern of salary, my lord, benefit as per wage board, my lord.
As per the UP one,
Yes, my lord.
which was given to Kachar.
Yes, my lord. Which was given to Kasar. My lord, I am in a difficulty to state that which was given to Kasar and not given to me because our salary has not been given totally, my lord. But they are getting, because of that, they are following UP pattern.
So you want to say that in respect to the similar sugar mills, this is also sugar?
Sugar mill, my lord.
In respect of a similar sugar mill, for the purpose of the cooperative sugar mill,
Yes, your lordship.
this mill, they have not followed while finalizing the VRS,
Yes, my lord.
the rate which should have been given as per the one which have been given to a similar sugar mill in Assam under the Assam government.
My lord, that is regular salary. When they have calculating the benefit on the basis of third wage board, which was existing up to 92 only, not as per UP pattern.
Which one? In Kachar also?
Kasar also, my lord.
No, Kachar has done it as per the 1989 one.
No, my lord.
Yes.
That was also as per wage board, my lord. That's what I am submitting, my lord.
No, 89 was your wage board, isn't that the wage board?
Yes.
Since
Because they
88.
have stated categorically in their affidavit that they are given as per the last wage board,
Yes, my lord. That was
the
old,
third.
about 20 years. That was old about 20 years.
Understood, 20 years, whatever may be, but that is what has been given.
Yes, my lord.
Now, is it your case that a similarly situated wage board, sugar mill was given more than yours?
Yes, my lord.
Or your entitlement would have been same with that sugar mill, that is Kachar?
No, my lord. But we are
Or in other words, Mr. Sekia, the entitlement which a person employee of this sugar mill had in terms with the VRS should have been same with the entitlement which a person has got in the Kachar sugar mill.
not exactly, my lord, because they are under AIDC and we are under.
AIDC
Person.
were only 122 were under the wage board.
Yes, my lord.
Now, is it the same?
Wage board is same, my lord, for both the mill.
So they are getting the same.
Yes, my lord. At when they are getting regular salary, the same.
Then,
Then, my lord, since 96, we have not received anything. And when provided the benefit, we have been provided on the basis of wage board, central wage board 3.
so that was the last.
That was the central wage board, last central wage board, my lord. but other who are getting on the basis of state government scale, my lord, they are getting 3 times higher than us, my lord.
How were they getting and the state government thing?
My lord, at the time of beginning of the meal, my lord, they opted for state government scale, and we are opted for West Board, my lord.
Now, was there an option to change your option at any point of time?
My lord, there is no such provision has been mentioned. I have not mentioned, my lord.
Have you challenged that aspect?
No, my lord.
If you have
I'm-
not, how can I help you? I'm putting so many questions to you so that something can be found out.
Yes, your lordship, but I am submitting only one thing, that for providing same service, my lord, because of not reason.
No, not on the basis of opting, because here is a question of opting.
Yes, my
Those
lord.
persons opted
My lord.
for state, because most probably, and you did not do it, because at that point of time, the central wage board must have been hired in the state. May have been.
That was at
The-
the time of beginning, my lord.
So that was higher.
Yes, my lord. That is
Now, there was an option. You do one thing. Here, recent judgment on pension
yes, my lord.
given by Justice Okha.
Yes, my lord.
Very recent judgment. Have a look at it. Can you develop your case on that?
Yes, my lord.
Very recent. I think it was given on 5th or 6th of May. On the question of pension, wherein it says the option which was to be given it was a responsibility of the authorities to inform.
Yes, sir.
Can you develop your case on the basis thereof?
Try my best.
You try your luck.
Yes, sir.
Mr. M. Soike, the learned counsel for the petitioner, Mr. G. Bodlo appears on behalf of the Corporation Department. Mr. Anjan A. Kulta appears on behalf of the Industries Department of the Government of SAC. On hearing the matter, the learned counsel appearing on behalf of the petitioner sought for some accommodation. Is the matter again on 16th, 2026, 2026.
26.
26, 2022.
26.
Oblige, your lordship.
This might require you to amend your petition also. Just find out if you can do something.
Item number 8 and 11.
May I please, Your Lordship?
Yes. Item number 7, 9, 10, and 12 have been withdrawn. 8 and 11. What is your matter?
Petitioner is a copyist working under the Fairness Tribunal, Kamrup Metro. And he was appointed on 25/11/2008 and still continuing
25/11/2008.
2008.
Okay, then
He has paid only some contextual amounts, my lord, not pay the minimum scale of pay, my lord. They have approached before this honorable court for their regular salary and not to terminate their services. That was the prayer in the writ petition, my lord. And on the basis of the High Court's order, they are continuing in their service.
now what do you want?
I want my salaries, my lord, though I have prayed
You
for
have got the
regulation.
salary after High Court's order.
Salaries, a minimum scale of payment. They have paid some different payment to different copies.
How do you get the minimum scale of pay? Because you don't come within the ambit of Upendas.
Only rupees 9,000 has been paid, my lord. The
Per
others
month.
has paid some more.
You are getting 9,000 per month.
Regarding,
item number 11, WBC number 2019.
2019.
2013.
Okay.
As per instruction received today, my lord. And regarding item number 8, though I have.
Wait. Don't jump from here to there. First, let us 2019. Let us see what is your case. What is your case? What are you asking for? Because you ask him now to pay the area salary from January 2009 till the disposal of the. Now, have you got any money?
My lord.
How many petitioners are here?
1.
So some amount of 2,08,000 has been given from 2013. You've got that money. Current salary are you getting?
Current fixed amount only 9,000 rupees.
You are getting.
Getting.
Not to discharge the petitioner from her service till her service is regularized in the copy so and so, which is presently functioning as so and so. To regular her service in the post of regular to this court can't give you.
Right.
Not to discharge till they are, isn't it the contractual appointment? Okay. Now, what is your claim? And what is your right to get these reliefs?
My lord, I am claiming for my salaries, my lord.
Salary too, you have got some amount of 2,08,000.
my
Now you are
salaries,
getting 9,000.
Enhancement of my salaries, my lord.
Enhancement, do you want this court to stand on the footing of a pay commission? How can I decide what is your enhancement?
But some other persons has got more money
So you want pay parity?
in contractual amount. My lord.
Where is your contract? Let's see. 2019.
Annexure she pays 31. It is my first appointment order. Engagement order. Pays 31.
This is on contingency basis. Why you are saying contractual?
On that basis, my service has been extended, my lord.
Understood, but this has been done on contingency basis. Contingency basis will be sometimes a person concerned may not be getting, there might not be for urgent requirement, this person may be appointed.
But we are appointed due to emergency situation, my lord.
Emergency situation. And then you are still continuing.
Still continue.
Now, what is the stand of the government? Yes, government, what do you say? Which government is going to say something? Now, Foreigners Tribunal, who is appearing for this? Finance. Finance will be the better person to say.
Actually, it's the FT member who will be the right person to.
No, FT members, we will go into this. When the question of money comes, first we will hear them.
One approval is there in the record. An item.
Now that I have seen it.
Yes. And now regarding the claim
Some
of the
2,08,000 was approved.
that.
Now here is the case, your stand of the FT people's stand is response number 6 and 7. Who are they? Response number 6 and 7.
FT members, Shivsagar and Tinsukia.
So their stand is that there is no sanction post. Now in FT there is no sanction post.
But not all posts.
No,
Not
here they are mentioning, if you see the affidavit which have been filed, more particularly at paragraph number 14. it may be mentioned that there is no sanctioned post of office for Foreigners Tribunal Tinsukia, and as such, there is no question of appointing any person as copyist in the Foreigners Tribunal
Yes.
Tinsukia. Are you saying that such an important Foreigners Tribunal, there is no post of copyist?
That affidavit was of my lord probably of 2013.
13.
By
Now what?
now, the things have changed, I suppose. Sir. Initial, and my lord, the claim of the petitioner for granting that minimum of the pay scale pursuant to Upendas, that came in 2017. The writ petition has been filed in, was filed in 2013. If
No,
one-
here he has not worked for that 10 years. No?
Yeah.
His appointment was in 2009.
Lordship.
Pendas comes on from 1/6/2017. So for 10 years before, so
That-
that
that's
will be
what-
from 2007.
That too, my lord, the petitioner is continuing pursuant to some protection given by his honorable court, my lord, if I'm not wrong. Because in item number 8, my lord, his services have been terminated otherwise, as per the affidavit filed as a member.
8 is your matter?
My lord.
186 of 2012.
No, tell me. The reason why the petitioner has not been,
My lord.
because no appointment, is there no post of office now?
Now, my lord, latest probably there is, and it's not that, my lord, cannot be that there is no post of office.
Yes, who is appearing for respond number 5, 6, and 7?
My lord, 5 for respondent number.
Yes, Mr. Sharma?
No, Lordship, I've been told that standing council is there, Lordship, for Foreigners Tribunal. কোন আছে? অঞ্জন বলছি। নাম শো করা নাই।
I think you should. The reason why they have not been appointed because there was no sanction post.
Lordship.
Now, if there is a sanction post, then I think you should go and advertise, let the petitioner also participate, and then whatever maybe we can only grant some relaxation taking into account his age for the purpose of all these things. That's all.
Yes, but my lord, whether there is a sanction post or not, my lord, that we can have the instruction, my lord, sort instruction on that point in this particular tribunal.
That is the only thing
Yes.
which this court can do.
It is Monday, my lord. On
Because
Monday,
this
my lord.
court, in view of Uma Devi, can't grant
yes.
regularization.
Well-
And that too, in item number 8, he is enjoying out there on the basis of court's order.
No,
So-
8, not 8, my lord, probably 11.
Whatever may be,
Yes,
in
yes.
one of these cases, he's
Yes,
enjoying
yes,
on the basis of the court's order.
Court's order.
So obviously, then in view of paragraph 53 of Uma Devi, no way out.
Yes.
Now, the power to give or direct regularization has been said that 226, this court can't do that. So where the matter ends. So the only way out is,
Well,
if something is to be given, is that the petitioner has been working for all these years, so you should also relax his age while if there is a sanction post to the
my
effect.
lord,
So the petitioner can also participate.
provided, my lord, the sanction post has not been filled up till date. That is also not a record.
Build up.
I don't know.
Because, my lord, to my knowledge, there was a drive of my selection, my lord, process initiated for filling up the post of copies, sanction post of copies. Whether
Because if you
participated
remember,
or-
there is another matter where Mr. I. Sakia is appearing.
Lordship.
That matter where specifically the question involved out there was for the purpose of, although Upendas does not come in,
My lord.
but in view of Jagjit Singh,
The 10 years.
not 10 years, that a person, if he is doing the same work, because Jagjit Singh does not have this 10 years business out there,
My lord.
that if he is doing the same work,
My lord.
then why not he should be given the minimum scale of pay,
Following Jagjit Singh, not Upendas.
Jagjit Singh.
Well, since the division bench of this honorable court, by relying, my lord, on Jagjit Singh specifically, has passed an order. My lord, probably this will be binding on this court also.
Oh, no, it's not binding. That 10 years was based out there, whatever may be, it has been done on in the area, but can you say
My lord.
that this thing of 8/6/2017 judgment, another now we have already passed 6 years.
Lordship.
And if you just fix this 10 years there, and then now another 10 years happens, can't we apply the principle out there?
Lordship.
That was given at that point of time in the year 2017.
No, my lord, there will be another, my lord, point of view. This on the day when the judgment was passed in 2017, whether this petitioner or any such similar persons were there in the post of contractual.
Not necessary.
or not.
Let us not assume they were
In
not.
future appointments, it may,
Let us
it may
assume-
change.
no, what is the basic idea behind Upendas? The 10 years from now, if these people have been working, kindly give them the minimum skill.
Not in nonsense.
Fantastic.
Yes.
Now, if it is a case of 2019 or 2020, the same principle if we can apply, 10 years from 2020, why not he should get it?
No, that's why I'm saying, my lord, if somebody is appointed after 17, and he claims
Your
that, my lord,
yardstick is 10 years. Yardstick can be taken as 10 years.
no, not in case of, my lord, fresh, my lord, a person who will be, my lord, engaged on contractual basis after that judgment, my lord. Because then we cannot say 10 years, because it is automatically it's beyond 10 years, my lord. Say in somebody is appointed engaged in 2018. If he works up, say 2 or 3 years thereafter, he comes up
No,
facing Jagjit Singh.
I'm not on that.
In that case, my lord, it will be different.
No, no.
But the
You see,
person-
the wisdom behind this 10 years
Then in that case, my lord,
is that
those
we are having
persons.
a person who is working for 10 years, so we are giving him the minimum scale of pay.
Yes, but date has been fixed, my lord.
Date has been fixed for that matter,
Fine.
because the court was deciding then. But,
Why
but
I'm saying is, my lord, moment the honorable court says that, my lord, 10 years, then those persons, my lord, who has worked for 5 years, they will not be entitled. Now then they cannot take a plea that I am not relying on Upendas, I will rely upon Jagjit Singh.
no, no,
No
no,
10
no,
years.
I'm not on that.
Yes. So that's why I'm saying.
See,
my
the
lord, other
court-
opinion,
Although Jagjit Singh does not say,
my lord. Nobody has, my
anything.
lord, challenged it, my lord.
Nobody has said, Jagjit Singh never says about 10 years.
Probably, my lord, the Umadevi part was, my lord, was there in the mind of the court, so that 10 years was added.
Maybe,
Maybe.
but 10 years were brought in. But let us assume for another, can you say on the basis of Upendas, which was done in 2017, the same 10 years will be only for this from 10
No, I
years
understand,
from
my lord.
this, then it will be
But that pertinent question will have to be placed before the division bench. That's what I want to say, my lord. If somebody
no,
is
no,
agree, we'll have to
no.
go.
You do one thing, I pass an order in his case, you take it up in the division bench.
But here, my lord, there is no.
Because
pleading or prayer to
recently,
that
if you
effect.
see, recently, there is a division bench order whereby it has the same benefit has been given to grade 3.
Well,
Then minimum of the scale of pay. In grade 3, it has been given. Why? It couldn't have been granted. You
But
may
if
say, you may very well argue that the division bench couldn't have passed this order to that effect because the division bench ought to have referred it to a full bench.
well,
The division bench have given it. Recent judgment of Justice, a Chief Justice, and I think somebody else was sitting. That day I got hold of.
well, without insisting for this 10 years.
No, 10 years. You see,
Not
the
grade
10
four,
years
but
will
grade
be.
3.
The
Yes.
10 years will keep on changing. The year will be 10. It will remain.
My lord.
But with the years going on, you can't have that fixed
yes.
big bracket out there.
My
Because
lord.
you see, Jagjit Singh never said that about 10 years or anything. Jagjit Singh said that if a person has been working in a on a contractual basis or whatever may be, if he's working out there and his work is same with that of the other, then he is entitled to, he may not be entitled for the pay scale which is otherwise that person is getting after 10 years because that is, he has got it on the basis of a regular selection.
Lordship.
But he will be entitled to the minimum of the scale of pay. That is the law which has been laid down. Now, while interpreting out here, the court thought that let us have something of 10 years together. We have to look into the question of 10 years.
My lord.
A person's right may not be ripe in the year 2017 when the judgment was passed in Upendas. But a person's right of 10 years may ripe in the year 2019 or as of now in 2023. Why not? He will be entitled to the minimum scale of pay.
That's why I'm saying, my lord, my lord, the contractual employees who were there in service at the time of passing of the judgment in Upendas, my lord, if they are agreed by this, my lord, 10 years, my lord, given, my lord, in the judgment, they will have to, my lord, challenge it, or they will have to go
Not
for it.
necessary, because
Any,
the
my
10
lord,
years has to
contractual
be
employees
taken on that
after-
basis. 10 years, you see, that
My lord,
was,
this
you
10
see-
years will be, my lord, otherwise redundant. This-
no, 10 years is not redundant. 10 years will all along remain. Maybe a person, maybe, just for example, today in 2023, I passed the order. 10 years will be taken from 2013. The 10 years remain intact. But the period will differ with person to person.
Lord, sir.
Because Jagjit Singh never said anything about 10 years or anything to that effect. Here only say.
But my lord, Upenda says, my lord, that the benefit will be given from July 2000, specific date has been given, my lord, July 2017. The moment-
Understood, but that is only for that post. And more particularly, in that case, those persons were asking for regularization.
Yes.
And on the basis of that, say that, okay, regularization, we can't give it to you, but they will be entitled to the minimum scale of pay.
My lord, on leave of that. my
If
lord,
you
this
see
was-
Upendas, read it. It was more of a consensus. Although there was this direction which has been mentioned that there is a direction to that effect. But otherwise, the state said that we are not going to remove these people.
Yes, that assurance was given.
The state said that we are going to give them some benefits as regards medical and all these things. We are going to give all these things. The court just added this particular line to that effect and said that this is, we direct that these persons so and so should also be getting the minimum scale of minimum scale of pay, and more particularly when the Supreme Court has stated out there in Jagjit Singh, Upendas won't trouble this court in passing that direction. I don't know, I will be obviously bound by a judgment of the Supreme Court more. And can very well read down the Upendas to the effect that it will only cover, it only meant about 10 years. 10 years will be.
That if clarification is given, that's a different issue.
Huh?
That clarification is given, then the law will be different normally. Anybody who has completed 10 years will be entitled for the minimum of pay scale.
Like Jagjit Singh has been clarified by the division bench, I can clarify the division bench. Yeah.
Like Uma Devi Melada was clarified.
You just find out that thing, because I think this needs to be done.
Division bench, my lord, similar method came up, not for copies, for other posts of FT, my lord, the tribunal. There some order has been passed.
No, in fact, the division bench had given the same benefit to grade 3 also. They give you that order. That day I was looking into, in fact, it was given. Got it. This was given on 3rd of May.
My lord.
I don't have the number because this life law, they didn't put it up there.
So if the name of the party is given, my lord, we can-
Name of the parties, I don't have it. But the High Court, Guwahati High Court was a party.
Probably finance is also a party in that case. my lord.
Definitely, the finance should be.
I can find out.
I'll just find out and let you know. Yes. Here it says review petition, so and so. Jagjit Singh following, huh? Then SP Sharma, as per Sharma, per contra, yeah, Jagjit Singh. In view of the above, the Jagjit Singh, which was reliable, in view of all above, the division rendered by the full bench in after Singh so and so is liable to be set aside. The decision rendered by the division bench is also liable to be set aside. Modification that the employees concerned would be entitled to the minimums of scale of pay of the category to which they belong, but would not be entitled to allowances attached to the post held. We have given thoughtful consideration to the submission advanced at the bar and have gone through the materials on record. At the outset, we may note the issue regarding the entitlement of the appellants to receive the minimum of the pay scale is no longer res intriga, because in the earlier round of litigation, while deciding so and so in terms with the amicable settlement arrived at with the state, the division bench directed that the appellants herein would be paid the minimum wages of regular pay scale from March 2017 onwards. It is an admitted fact that the appellants were actually granted all the benefits of the minimum pay scale, including allowance till January to the contents of the letter of the Auditor General so and so. Apparently, thus, the nature of the services of the appellants were neither ad hoc nor daily wages. They were definitely temporary employees appointed against temporary posts created for newly set up fast-track courts. It is true that at the inception of the service of the appellants may have been declared as coterminous with the existence of the fast-track courts, but the fact remains that even after the fast-track courts were abolished, the petitioners continued to be utilized in different judicial courts. Hence, it is not a case that the petitioner lost their utility to be the judicial courts after the system. That is why the state government came out with the scheme of a settlement during the course of hearing of the review petition and offered the minimum of the pay scale to the petitioners so that their experience of working in the judicial courts could be utilized, and they too could be offered a chance of working with dignity by offering them the minimum of the scale of pay. There cannot be any two views that the pay scale, even if it is of the minimum applicable to the post in question, would include the allowance. In this background, the contention of the learned counsel appearing Mr. P. Nayak, that the claim of the petitioners is hid by the observations made at paragraph number 55 of the judgment rendered is absolutely unacceptable. Those observations were made by the Supreme Court while considering the case of daily wages, work charge, and contractual employees. However, quad temporary employees, in which category the appellants clearly fall, the Honorable Supreme Court went on to discuss the issue from paragraph number 12 and held that such employees would be entitled to the minimum of the pay scale. As there is no observation in the said judgment that the temporary employee would also be deprived of the allowances, the petitioner would definitely be entitled to the claim of benefit of the observation of so and so. In view of the position expressed by us in the foregoing year, we have no hesitation in holding that all the temporary and the concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay at the lowest grade in the regular pay scale extended to regular employees. It is not in dispute that those from the petitioners who are holding grade 4 posts have already been extended the benefit of minimum of the pay scale as well as allowances attached thereto by virtue of the government's notification dated 8/3/2019. Hence, excluding the remaining so and so who are serving in grade 3 and denying them the benefit would be violative of Article 14 and 16. As a consequence, the appeal so and so. So, therefore, irrespective of that, these 10 years has to be taken into account as period specific. Are you going to say in 2025 or 2030? And look here, that division bench only was 10 years, but these people have been working for 10 years, 15 years, 20 years. Are you going to say, no, you can't? The prescription is only 10 years. Because Jagjit Singh never said that.
It will be like a qualifying service for 10 years, then
Qualifying service. Then only the interest of justice would be. Isn't it?
the FT standing council is here.
Yes. Division, FT standing councils going to the division bench must have forgotten about the single bench. Yes, tell me. Whether these posts, copies, there are you have regular posts out there, sanctioned posts in Tinsukia, and which place?
Tinsukia right now.
Both Tinsukia.
Tinsukia. And regarding item number 8, he is in Kamrup Metro.
Kamrup Metro and Tinsukia, you don't have sanctioned posts of copyist.
Lordship, I need to take instruction, Lordship. 2 days or 3 days time may be allowed, Lordship. I will provide the instruction, Lordship. Detailed instruction, Lordship.
I think 8 or 9 meeting.
Accountant General has also filed affidavit. And this is the best affidavit I have seen. That I am so and so, save and accept that with regard to the statements made in paragraph number 1 to 21 under your deponent states the matters and no comments to offer. Please. That the statements made in paragraph 1, 3, and 4 are true to my knowledge. Hello. Heard, Mr.
Dibora.
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 Dibora, the learned counsel appearing on behalf of the petitioner. Mr.
G. Sharma.
G. Sharma appears for the Foreigners Tribunal. Now, what is that? You are appearing for which one? Foreigners FT?
Yes, Lordship.
There is a department of FT.
Yes, Home and Political B Department.
You are appearing for Home and Political
Political
Department.
B. Yes, Lordship.
Appears on behalf of the Home and Political Department B. Mr. You are appearing?
No, Lordship, I'm not.
Okay, Mr. B. Gogoi appears for the Finance Department. And you?
B. Sharma for CAC.
For?
CAC, Central Government Council. B. Sharma.
B. Sharma appears on behalf of the central government. Upon perusal of the materials on record, it transpired, more particularly from the affidavit filed by the respondent number 6 and 7 in WPC number 2019/2013, that the petitioners herein could not be appointed against regularly, taking into account that there was no sanctioned post of copyist in the Foreigners Tribunal Tinsukia. Be that as it may, taking into account that the affidavit was filed in the year 2013 and almost 10 years have passed by, the learned counsel appearing on behalf of the Home and Political Department B of the Government of Assam is directed to apprise this court on the next date as to whether there are sanctioned posts in the post of copyist in the Foreigners Tribunal of Kamrup Metro, as well as Tinsukia. Further to that, the learned standing council is also directed to apprise this court as regards the present status of the petitioners in the said Foreigners Tribunal, as in the capacity as kept copies. When?
Thank you, Lordship.
When?
1 week time maybe allowed.
This is an old matter. Looks very. We'll have it on 25th of May.
Yes, Lordship.
This is the matter on 25th of May.
Name of SC Standing Council Foreigners Tribunal may be shown in the post list.
The registry shall show in the name of Mr. G. Sharma as the standing counsel for the FT in the contest.
Both the matters take together.
Yes.
8 and 11.
Next. Yes, Mr. What is your matter about? Item number
Lordship petitioner was appointed as 13 Lordship.
Item number 13.
Very old matter again.
Lordship. Petitioner was appointed as peon Lordship in Food and Civil Supply Department, Sadia Lordship.
Petitioner was appointed as a peon.
Peon Lordship in 1996 Lordship. Up to 2006 Lordship, he has been paid Lordship. After 2006 Lordship, his fixed salary was not paid, and petitioner approached the Honorable Court in 2011 Lordship. And this Honorable Court was pleased to release the salary Lordship. The Honorable Court's order is Lordship into 27 Lordship. Page number. Operative portion is 28 Lordship. Okay.
Yes, Finance Department, where is he? Finance Department is a party.
No, Your Lordship. It's not a part.
Why haven't you made the Finance Department party? It is on the basis of the Finance Department circular.
Lordship, sorry.
This is why the Finance Department, in which the engagement under has not been denied. It has been stated that since the petitioner was appointed after the payout of Iman and Iman, his salary could not be released in absence of a budget petition required approval. Whatever form, please.
Yes, sir.
Mr. Counsel, don't you think without the Finance Department, how can you get your relief? Tell me.
Lordship, may I say, Lordship, after this Honorable Court's order, Lordship, his area salary has been released, Lordship. And after that, Lordship, in page number 31, Lordship, the impugn notification office memorandum and
Is to revise the fixed salary of rupees 3,000 per month admissible to casual employees in the Assam expense appointed on the full-time basis.
Sorry.
On governor was pleased to enhance the rate from 4,000. Yes, then
impugn order, Lordship, in 35, Lordship.
that I've seen that by
Lord.
which I request you kindly to take immediate steps to
Lord.
retrench so and so as per Finance Department circular.
Lord.
Also to the why? Which is the circular?
Lordship, not just this order has been passed, Lordship. Lordship, may I say, Lordship, the
This one. Where is the circular 21/12/2012? And also take up the matter with the senior government advocate for filing an appeal intimating the position for avoiding financial burden. What have you done? You have sought for retrenching him.
Lordship, he has actually been retrenched before even filing of this writ petition. I don't know whether he knew it or not, and possibly he must have known, because otherwise how do you keep on continuing, Your Lordship? This retrenchment order has not been mentioned in our affidavits, but it has not been annexed, Your Lordship. But otherwise, we have mentioned that on 23/2013 he has been retrenched, Your Lordship.
Then
And thereafter, Your Lordship, this all the payment till this December 2011 has been made, Your Lordship, and he has been retrenched on 23/2013. So at best, Your Lordship, that period, whether he has received the money or not.
19/9/2013, there is an order of status quo.
Yes, status quo. That is why I said that he had actually been retrenched prior to that, Your Lordship. And we've mentioned it in our affidavit, and they have not filed any affidavit in reply, Your Lordship.
Where?
Lordship, in the affidavit in both our affidavits, but in affidavit of respond number 3, Your Lordship.
Ramakrishna.
Yes, Ramakrishna and page number 3, third page, Your Lordship, para 7.
Directed for retrenchment of such So he was retrenched on
Lordship, since
3, 2013. This was filed at least in August or something, Your Lordship, not before that.
No, this was filed on 9th of December 2013. He was retrenched. Then affidavit in opposition has also been filed.
Yes, both two affidavit in opposition has been filed, one for spot number 3 and one for spot number 4, Your Lordship. To this, there has been no affidavit in reply clarifying if there's any, he knew, he didn't know anything, but otherwise, if he's retrenched, how does he keep on working, Your Lordship?
Where have you mentioned in the next affidavit?
Lordship?
With regard to the statement, he was retrenched as per the direction of man dated 2/1/2013. So there is a government, so it was done on so and so, you are retrenched. Okay.
Lordship, may I give the retrenchment order? I can give it to him also, to Your Lordship also, I can.
Show me. Why you
Lordship,
have not
I
included?
had to contact the petitioner, Lordship, since long back, Lordship. And two now mobile number also with me, Lordship. But both mobile number is invalid and I could not contact the petitioner, Lordship, since long back, Lordship.
But unless you challenge the retrenchment order,
Lordship,
you have no
I
case.
tried to contact, Lordship, but
Understood that, but I can't help you.
Lordship.
If you have,
Yesterday also, Lordship, I tried to,
no, if you have a case,
Lordship.
because you have to tell him, there was an affidavit filed long
Lordship.
time back.
Lordship.
If the petitioner know, because once he is retrenched, he
Lordship.
knows it.
Lordship.
He has not come before this court.
Lordship.
In fact, he must have hidden it to you while filing the writ petition. Because you see, you filed the writ petition sometime on
Lordship, 2013, Lordship.
You filed it on 10th of September 2013.
Lordship.
And you challenged the order of 2/1/2013.
Lordship.
Whereas in the month of
23, 30, March.
23, 2013, he has already been retrenched.
Lordship, I after that filing case, Lordship, I tried to contact Lordship, no response, Lordship. Two mobile number is with me, Lordship. Both are invalid.
Maybe the petitioner is not interested. I'll close it.
Lordship.
No way out. Because you have to challenge. it.
Lordship.
Mr.
Yes, sir, my lord, sir.
Isham, the learned counsel for the petitioner. Mr. C.H. Hazarika appears on behalf of the respondent number
1 to 4, all.
1 to 4. The petitioner hearing has approached this court challenging the order dated 22/1/2023, whereby a decision was taken for the purpose of retrenchment of the petitioner on the basis of the office memorandum dated 16/6/2012, on the basis of the government's letter dated 20, on the basis of the Finance Department's circular dated 16/6/2012. The instant writ petition was filed challenging the communication dated 22/1/2023, the 13, whereby the Deputy Secretary to the Government of Assam Food and Civil Supplies and Consumer Affairs Department have written to the Director Food, Civil Supplies and Consumer Affairs, directing him to immediately take steps to retrench the petitioner as per the Finance Department circular, and also take up the matter with the senior government advocate for filing an appeal intimating the position for avoiding the financial burden. It further appears that on 23/2023, the petitioner was retrenched by an order passed by the subdivisional officer FCS NCA Tinsukia district. However, there is no challenge to the said order. It may be relevant here to mention that in the affidavit in opposition filed by the respondent number 3 on 9/12/2013, the fact that the petitioner was retrenched by an order dated 23/2013 has also been mentioned at paragraph number 7. Thereafter, also, neither there is any affidavit in reply nor a challenge made to the said order dated 23/2013. Taking into account the same, as there is no challenge to the order dated 23/2013, by which the petitioner have already been retrenched, nothing survives in the instant with petition. Accordingly, the petition stands dismissed. The copy of the order dated 23/2013 is kept on record and marked with the letter X. Mr. C.S. Hazarika, the learned counsel appearing on behalf of the respondent number 1 to 4, have also served a copy of that order to the learned counsel for the petitioner during the course of.
Lordship, I am extremely sorry, Lordship. I have not aware of the
So
reason.
you do one thing, put it out there, so that if he wants to file, he can very well file. Arasani, this says, yes, one Purana. Uh-huh. 2013 or?
I don't know, 14.
Yes, Mr.
Except
Bro.
that, in that case, last occasion we obtained from the time to obtain the copies of an repetition, Lordship.
Oh, the perusal of the also finds that the annexures are not legible. Considering the, let the matter be listed immediately after Bihu vacation. Bihu has gone. Now we are Bahagi Bidai. Just tell me.
Lordship, that unfortunately, Lordship, that we have some due to some communication gap, Lordship, that we could not collect the copy. It had not applied. So, Lordship,
The 2013 matter it
Lordship,
doesn't
that
look nice.
even- Lordship, what happened in that in this case, Lordship, initially repetition was disposed of in our favor. Thereafter, respondent preferred an appeal, and matter was remanded back to the single judge for reconsideration of the certain issues.
Fantastic. Now let us see
order of
what
an-
is the consideration.
Order of an writ appeal was
What are you asking for?
13 and 2000, Lordship, the parity of an pay scale, Lordship.
What is your case?
Case is that, Lordship, the petitioner is the radio mechanic in the graph general
Calling upon the three
Reserve
revised scale
engineering
of
force.
5,000 to 8,000 revised pay scale of rupees 93, 9,000. Yes. So you are claiming the pre-revised scale of 5,000 to 800, revised scale of 9,300 to 34,800.
Lordship. That is our case,
On the date you were appointed as a radio mechanic.
radio mechanic. No,
Now,
Lordship,
why
on
the
that,
matter was again remitted back to this court after the matter has been disposed of? Repetition was allowed.
Initially, repetition was allowed.
Insurance of the division bench have held that the petitioner do not have any right to recover area beyond so and so. Resolution has been filed. The above being said, the prayer of the hearing is extended to the creative towards of that they have been granted the pay scale of human the pay scale of with effect. Now, this MSCP and ACP and all these things, whatever increases is not the pay scale.
Lordship,
Only the grade pay is being increased. Now, you have been granted that now you are getting 9,300 to 34,800.
Lordship.
How much are you getting now?
Now, Lordship, that we are paying for, we are claiming the equivalent to the pay scale received by the surge signals. We are the radio mechanic. During the course of our service, Lordship, we are promoted to the post of the surge mechanical. In the surge mechanical, Lordship, into the entry cadre, there are two rules. One, by way of the promotion, and another way of the direct promotions. Since we are promoted, we are claiming for the same pay scale of the surge mechanical, who are getting.
Show me the division bench order. Why
That
it was
Lordship,
returned
that
back?
is 13/2019.
13?
It is the order of a division bench is the 13/2019.
Show me that. Unnecessarily matter has been come back. It should have been disposed of right there.
Lordship, that give me an opportunity.
What has happened out here, the division bench says there was the single judge has on a wrong assumption that chargeman signals diploma holders are presently enjoying the pay scale of 5,000 to 8,000, while the petitioners are getting lesser amount. The decision was made. And therefore the matter has been remanded. Now the chargeman is getting same.
So Lordship, that also I need to take some instruction, Lordship. That also.
And who is appearing for the central government or what?
Lordship, B. Chakraborty is appearing, Lordship.
No, Mr. R. Muzumdar was appearing on the last
He is
occasion
appearing for the,
Wednesday.
yes, Lordship. He is appearing for a petitioner. He is my senior, Lordship. Today, due to some personal difficulty, Lordship, today he is left the court premises. And the copy has also not been taken, certified copy.
It's a 2013 matter. It doesn't look nice. And nobody is appearing for the central government.
Lordship, Mr. B. Chakraborty earlier appearing. Then
So he has left hope. No central government. Anyways, okay. It's a whole matter. It doesn't look nice.
Lordship, Mr. B. Chakravarti was here, Lordship. He has left due to some personal difficulty.
Heard Mr. H. Bezbulwa, the learned counsel, appearing on behalf of the petition. None appears on behalf of the respondent, central government on call. This court, by the order dated 23/3/2023, directed the respondent authorities and directed the petitioner to produce the annexures, produce legible copies of the annexures. Almost 2 months have passed by, but the same have not yet been done. Anyway, be that as it may, let the matter be again listed on 20 June 2023. Taking into account that the matter pertains to the year 2013, if the petitioners failed to make due correction in terms with the order dated 23/3/2023, this court shall proceed with the matter without taking into consideration the illegible annexures on it.
Much.
Again.
Fifteen.
Yes. Oil cuts across. What is this? Affidavit, additional affidavit, so many. Yes, what is this matter?
We are praying for increase in the minimum wages of the petitioners.
Who are you? These people?
They are the members of the Village Defense Party also.
Village?
Defense Party also. It's as per the Act law.
What are they used for?
They are called in terms of the Assam Village Defense Organization Act 1966. Also. They are deployed by they are under the control of the Assam Police. Also. And as per the requisition made by the Oil India Limited, also they are deployed by the Assam Police, and accordingly
that day, yesterday I was taking up some matter to the effect that NEPCO one, similar to that. So tell me, yes, Mr. Sharma, this matter you deploy all these people there.
Yes,
Now you are the appropriate government.
Lordship. No, Lordship, they are voluntary organization. They are not entitled for even payment also. Only some pocket money is given to them.
Yes, Lordship.
They have as because under the Act of 1966, they are engaged and they volunteered their services to help the police over personnel, Lordship. And as per request made by the Oil India Limited, they are engaged by Oil India Limited.
And accordingly, as per the advice of the Assam Police, Lordship, the payments were made. Now they are getting 100 rupees per day, Lordship, because there is a bar to the remuneration as per the Act, Lordship, clause 10, bar to remuneration. No members of the organization shall be entitled to any remuneration, but commendable services, including welfare work by any members, may be suitably rewarded as may be prescribed. So they are know about the terms and conditions of the that Act, and accordingly they voluntarily they came, Lordship, and accordingly the Assam Police has deployed the same. Now they have spring in this requisition, Lordship, absorption.
Absorption is correct. No absorption.
And they are only enrolled, not enrolled, Lordship. That word enrolled is there in the Act.
Lordship, but one subsequent development, Lordship, pursuant to this requisition filed, Lordship, in the year 2016. Thereafter, we have filed our affidavit showing all the terms and conditions of the Act, Lordship. And thereafter, one of the petitioner also, they have filed a writ petition challenging the said rule, clause 10 of the Act. And accordingly, the revision bench has now directed
Lordship, by order dated 13/5/2022, directed the state government to come up with. We are satisfied that petitioner deserve for hike of their remuneration. Lordship, honorary.
Minimum wage is a concept. The matter is pending. What is the basis of the minimum wage?
Look, in this situation, they are as per Upenda's case as well as the which
No, forget about Upendas. Upendas is minimum scale of pay. I'm not on that. About the minimum.
in this case, Lordship,
Person.
there are some direction was
They come within the ambit of watch and ward. You are the appropriate government.
Lordship,
You are the appropriate government.
Lordship.
So, can a person be employed in an establishment
Lordship.
without payment of the minimum wage?
No, Lordship, actually, if we go by the Act, Lordship, in the Act, it is stated,
No, not that act. I'm not
right, we are, Lordship, we are talking about the minimum wages.
full-time.
They are not the, they are volunteers, Lordship.
Only some is course Sata like course Sata like
The state government may constitute an organization to be known as the Assam Village Defense Organization, and for that purpose enroll any adult citizen of India who may offer himself to be enrolled.
Mr. Council, do you come within the ambit of the minimum wage act? Have you ever seen this act before stepping foot out here and doing the matter? No. Then, do you think that this court is going to keep on helping you? Appear just for the sake of it. You see, who is an employee? Employee means any person who is employed for hire or reward to do any work, skilled or unskilled, manual or clerical, a scheduled employment in respect of which minimum rates of wages have been fixed, and includes an outworker to whom any articles or materials are given out by another person to be made up, cleaned, washed, altered, ornamented, finished, prepared, adapted, or otherwise processed for sale for the purpose of trade or business of that other person, where the process is to be carried out either in home of the worker or in some other premises, not being the premises under the control and management of that other person, and also includes an employee declared to be an employee by the appropriate government, but does not include any member of the armed forces of the union.
minimum wage এখন নাই ন থাকিলে কিবা
Now, any payment which partakes the nature of layoff compensation cannot fall within the term of wages. Now, do they come within the ambit of the scheduled employment? The work while India?
Lordship.
Do they come within the ambit of the scheduled employment?
They are not engaged, Lordship.
Do you have the minimum wages notification? Or not heard about it? You've heard about it. Which year your service have been included? You come under what ambit? What is the scope? You must be aware that when a minimum wage notification is issued, there are in various schedule employment which is being given. Now, schedule A, schedule part 1 and part 2 is also there somewhere, if I'm not wrong. Part 2, employment in agriculture, that is to say in farming, including cultivation, tillage, so and so, bees, poultry, so and so. So consumption, farming, so and so, timbering and preparation for market and delivery to storage. Because you see, these, if you see those employed, the daily rated wage, they are not employed.
But Lordship, they are not only 10 or 14 members, Lordship. As on 2016, they have the 19,881 registered village defense party. Lordship. 19,881 registered village defense party under the control of the Assam police.
No, I'm not on that. I'm saying the Assam government need not pay that. But the moment the government provides you with somebody,
I have just forwarded.
They are paying.
No, then wouldn't it be necessary? Because why is the minimum wages? Minimum wages comes from Article 22. 22 or 20, whatever. To the effect that a person, you cannot allow a person to work out in your place without paying him something. And that something is the minimum wage.
But Lordship, in respect of VDPs, there is a guidelines, Lordship. Lordship may use the page 36, Lordship.
Those are different things. But you see, these village guidelines, organization act, whatever may be, these keeps on happening out there. I'm not on that. But once they come under your control, here it say minimum wage of rupees 100 per day per VD member is proposed for those employed in ONGC, oil, so and so, so and so. This was done in the year when? On 8/6/2022. Now, how could they fix it? These people fix it.
As per Act, Lordship.
Mr. Counsel, as per Act, if a minimum wage is to be fixed, it can be fixed only by the appropriate government.
They are ultimately volunteer, Lordship.
Whatever may be.
They are not full-time workmen, Lordship.
You see, tell the government out there, we don't require these people. If we don't, we can't pay more than 100 or whatever may be. But whether they are entitled or not, first of all, who are these people to fix the minimum wages? Minimum wage can't be fixed in this manner. Minimum wage can be fixed in the manner stipulated under Section 5 of the Minimum Wages Act.
Therefore, Lordship, pursuant to the division bench order, Lordship, on next day they have stated at the bar law that there is a proposal to enhance the honorarium of the members of the PDP assigned with the task of protection under security of the
Mr.
oil
Mozumdar,
pipeline.
you are there in that matter, in this matter.
Well, here what has happened is initially they follow a process of recruitment.
They follow a process of selection to take us into the oil Suraksha thing. And thereafter, my lord, what they do is they depend on the VDP Act to say that there is no remuneration to be given. Therefore, you have to work for free. We are giving you 85 rupees a day, and that is what you are totally entitled to.
No. Whatever may be, let us not go into those aspects of the matter. You see, minimum wages is the amount which needs to be paid on the basis of a declaration given under Section 5 of that.
Yes, ma'am.
The definition of employee definition is very wide.
Yes.
For minimum wage. The same can't be brought in the same aspect as the payment of wages.
Yes.
Or payment of bonus. Those aspects of the matter would be different. But for the purpose of minimum wages, this is the minimum which has to be paid.
Has to be paid.
On the basis of Article 20 or 22, whatever may be the case, that the persons, once you take the service, you are to pay
the minimum wage. But the respondents, when this was raised in the court, the respondents took a plea that the VDP Act debars payment.
No, VDP Act may debar payment from the state government.
Yes.
But the moment they are taken by some other people, then they have to pay.
Now, since we work under the instructions and authority and everything of the state government, they deploy us. The oil requests the state government and the state government deploys us. We have continued to work for so many years. Now the state government says that we need not pay you, but we are still paying you 85, you'll be happy with it. Our case was that it is minimum wages that we need it. When they came up with the VDP Act to say that we can deny it on this ground, is on that ground that that a writ petition was filed challenging that portion of the VDP Act.
What is happening there?
My lord?
What has happened there?
My lord, last time you were
just now, Lordship has go through the order. I have.
No, that was long time back.
Thereafter, it has not been listed.
Thereafter, the matter was again.
Was it?
Shall without fail
Again listed on
submit the concrete proposal for enhancement of the honorarium of the petitioners on the next day. That is one aspect of the matter. But the main aspect of the matter is the moment the state government puts you with somebody,
yes,
whether that body is not liable to pay if it is a notified industry within the meaning of Schedule 1, Part 1 and Part 2.
It is.
If it is a scheduled industry, has found by that.
Lordship, if subject to correction, my lord, Nihal Singh's case, that is what exactly happened. State government had taken the special police officers and posted them in banks. And when the banks refused payment or regularization was refused, that is when the Supreme Court had interfered to say that posts will not fall from heaven. You used these persons for particular jobs. There is no denial of the fact that these people were doing the jobs and they continue even now. So they, in that case, particular case, even the regularization was given, the salary, everything was given. But in our case, the state government simply wants to wash off the hands. And in fact, madam, oil now tried to take a stand.
I'm not saying that the state government would be bound by that.
We are not even going to that extent, madam.
But the moment oil keeps it,
yes,
they have to.
And oil in their affidavits have not denied that they have not stated that they don't want to pay us.
If they are under the employment of oil is the employer, then wouldn't it come within the ambit of the central government? Because oil's appropriate authority would be the central government.
Oil has not employed us. That is the stand of the oil is they have not employed us as such.
It's not required to be employed. You don't need to be given an
Realized of the
appointment
services.
letter. But their appropriate authority will be the central government. Once it is the central government, if you are in the business of watch and ward, then obviously it comes within the ambit of a scheduled employment as per the central government notification. If that be so, why not you will be entitled to?
The minimum.
I think what has happened that day also, I was looking to another matter, that was a matter pertaining to NEPCO. What is happening, in fact, a matter came up yesterday. All these persons concerned are home guards. and they are being put out there in NEPCO in various installations. The case of the petitioners herein is that, look here, I am entitled to the minimum wage which is being normally paid by NEPCO in the same installation in respect to home guards under the Mizoram or Meghalaya with that of Assam. That is one aspect. The second aspect of the matter is that I am entitled to the minimum wages. And the central government was a party to that proceedings. The central government has also categorically mentioned in their affidavit that yes, they come within the ambit of this and as such they are to pay this minimum wages. Now the government has taken, the Oil India or NEPCO has taken time for that. I'm fixing it again on today. What was the matter? I fixed it again on 26. Oh, I have fixed it on 2nd of second. I fixed it on 1st of June. That matter. And asking them to file their reply by 29th of May. I fixed it on 1st of June. So that matter. So that is a matter pertaining how it has developed. Now, whether the government gives or not, I'm not on that. Whether the matter pertaining before the division bench is as to whether it should be enhanced or not. Well, another aspect of the matter. This is a document which is being given by the Office of the Chief Controller Village Defense Organization Assam, wherein in a minute it has been fixed that the minimum wages of these persons concerned would be rupees 100.
100.
Now, interestingly, how a minimum wage is to be done is as per Section 5.
Yes.
And it has been to be done by the appropriate government. It can't be done by this, whoever it is. Who is this? Inspector General of Police or the Additional Director General of Police have no business of it.
Admitted in an affidavit that it is to be done by the state government. You also have page 27 of the repetition.
No, not necessary. You don't require an affidavit for that, whether they admit or not. But this aspect of the matter, these people have no business out there to do it. It has to be done by the appropriate authority. Once the appropriate authority does it, wouldn't they now, fixing the minimum wages out here, admit that they are your employees?
Yes. Now they admit.
Now, if you see the further definition of employer and employee in minimum wages act, a person whose services is also being forwarded to another would also come within the employee or employer. So why not oil? And oil in terms with the central government notification, we'll fix it on first, prepare.
Since the Union of India is not a party, application for the Union of India is not a party here.
We have never thought about it. What to do? I can't help you out. Heard Mr. R. Muzumdar. And Mr. Muzumdar, what has happened to that annexer? On the last time when the matter came up before this court, you said to me, that, my lord, I'm sorry, I can't do the matter today because the annexers are in a waiver, bad shape. That was in the month of March. We are in the month of May. Then we have nothing out there. This court is not going to look into those annexers and dismiss it on that. Heard Mr. R. Muzumdar, the learned counsel for the petitioner, Mr. H. Sharma appears for the respondent Home Department, Mr.
K. Kolita.
K. Kolita appears on behalf of the Oil India Limited. Let the matter be again listed for further consideration on 1st June 2023. Think about that. Okay, let's rise. Any more matter?